Now we are joined by Chief Legal Analyst Khalif Rhodes. Khalif, you're a former chief magistrate. You got some pretty good knowledge about how these type of things play out. What happened here? Was it judge discretion on the case, prior criminal history, as Robin was just talking about, or just by going by the letter of the law?
Let me say a couple things. I have intimate knowledge of how that portion works in being a criminal defense attorney who primarily handles homicides. I typically know how that portion works as well. What I can say is this is not the normal case that an individual facing a homicide charge typically will go to the magistrate's office, go to their first appearance, and there either will be no bond at the magistrate's level by statute. They would get to the district court level, and the district court typically wouldn't touch it. They would go to superior court, and they would set some type of bond, maybe in the hundreds of thousands of dollar range, or continue the no bond. And then months would go by, and then there would be an opportunity to address bond typically. So this is normally not how it happens. I'd say maybe once or twice I've seen this in the 14 plus years that I've done this, where the defendant is charged with a homicide case and the district court judge sets a bond similar in this range, but never where it's combined with a rape charge connected with that. So this is abnormally an unusual situation. It would probably be a combination of things. I mean, his history, he had no criminal history, but that's normally not enough. I mean, you have to look at the statute. The statute requires a number of factors, specifically the likelihood of this person committing a crime, the likelihood of committing a new violent crime, and their likelihood of appearing. And so when you weigh those types of things, specifically, the judge is looking at the weight of the evidence and the nature of the charge. And even though there's 13 total factors, those two factors are the ones that they are going to harp on. And so the nature of the charge, a homicide and a rape case, typically would deter a district court judge from setting any bond, and a superior court judge setting a really, really high bond.
You know, there is the public outrage here. There is the public perception of something like this when you let somebody out who has been charged with this. And then there's also Chief Jennings who says this just shouldn't be happening. Does the DA district attorney have any kind of input on something like this?
Typically, the district attorney will be standing right there and they'll say, Your Honor, I object to that. And so this person would have either been represented by the public defender's office or would have hired an attorney. And so they would have brought them to their initial appearance right there at their first level. And the judge, the defense attorney would have been saying, Your Honor, he has no criminal history. He's alleged. Obviously, these are only allegations. My client has not done anything, set a low bond. The DA would immediately stand up and say, no, Your Honor, this is the charge. This is why. And it would be that back and forth. So, yes, they have an opportunity. Regarding Chief Jennings' comment, and I've talked to him about this before in the past, these are the types of things where he talked about making the changes in the past for the rape charges, for the violent crime charges, where the magistrates can't set conditions for release. If he's saying that he believes no conditions are for release or should be set to make the community feel safe, that's the General Assembly question. That has nothing to do with the judges. That has nothing to do with the magistrate's office. That is typically a General Assembly because they can change the law. At any point, the General Assembly could say, instead for murder, having a judge having an opportunity to set a bond, there should be no bond. And there's some states that have that. They have detention statutes that say, I don't care what you want to do, you can't set a bond on this type of charge. North Carolina doesn't have that. And so his issue really isn't with the judge, it's with the General Assembly. And before, when he felt like the issue was with the General Assembly, what did they do? They went up there and they petitioned the General Assembly to make changes. And so that's typically what happens. I think this is a step in that direction. Making statements like this allows Raleigh to know that you're not happy with the outcome from this today, but it has less to do with this actual case and more with making changes.
We just kind of saw that with some of the laws regarding teens and violent
with juveniles,
crimes, 16 and 17-year-olds.
This is the flow, because if you look back 2 years ago, they made those same comments about teens, and now the laws are changing.
Laws are changing. All right, Chief Legal Analyst Khalif Rhodes, thanks for breaking it down.